Hello, everyone. My name is Richard Myles. I'm a graduate student here at Purdue University Global, and this is my last assignment for family law. It's in the Master of Science in Legal Studies program. It's 508, the course number, and it's taught by the amazing, and I repeat, the amazing Mrs. Jessica Gavin. And I'll tell you something, and I hope that you're listening, Professor. This is my third master's. I'm very pro academia. I love being in a classroom, or I just love learning in general. But I will tell you, I've had some amazing professors, but Mrs. Gavin is by far my favorite professor. And I mean that on a professional level. I think she's extremely passionate. I know she's extremely passionate about teaching. She's not just doing it for a paycheck like some professors, but she's doing it because you can tell she really loves teaching. It's just the energy that she exudes during her seminars. Even when I'm texting her, asking her questions about certain assignments, even through text messaging, you can just feel that energy that she just loves teaching. And I tell you, she definitely left a positive, indelible impression on me. And I want to thank you, Mrs. Gavin, for inspiring me to complete this program and also to pursue a fourth degree. I'm thinking about maybe an EDD degree or the Executive Juris Doctor. I haven't decided yet, but I'm definitely going to pursue a fourth degree as long as my health is good and I'm able to financially, keep afloat. That is my goal. So thank you, Mrs. Gavin. So this presentation is going to cover three specific model rules of professional conduct pursuant to family law in the state of New York. I'm also going to cover case law regarding an attorney that violated one of the model rules of professional conduct and the resultant outcome of that specific case. I'm also going to explore another case that deals with ethics and opinions. And I'm also going to cover how a griever can file a complaint with the ABA in the state of New York, but in this particular case, it would be the Attorney Grievance Committee here in the state of New York, and the process, which is quite overwhelming, and that's an understatement. But again, the resultant outcome can definitely make a difference in terms of deterring future potential violators from deviating and contravening the model rules of professional conduct. So I'm going to cover that, a step-by-step process, and how to file a complaint against an attorney that a person believes has violated the model rules of professional conduct. So I'm going to cover that and also talk about gender bias and also intersectionality, the dynamics of intersectionality, meaning that you have all these different demographical dynamics happening at one time. For example, you could be a female, you could be indigent, you could be a person of color, you can be someone that's gay. I'm just giving an example, right? That's the whole definition of intersectionality, right? That a person can have all these different things exist at one time and face discrimination from all of those different aspects of their existence. So we're going to explore that and hopefully come up with some kind of resolve to eliminate or at least reduce the quotient of biases in the legal system, but also with the interdisciplinary professionals who evaluate and assess family dynamics and their implicit biases when it comes to who they believe that the children should reside with. So we're going to explore all those different things in this presentation. Enjoy it, and enjoy it, and we'll conclude this presentation with some final thoughts. Okay, ladies and gentlemen, we're on page 3, or I should say slide 3. So the first model rule of professional conduct is 1.3, which covers diligence. Rule 1.3 requires attorneys to represent clients with reasonable diligence and promptness, which is particularly important in family law matters involving deadlines, custody, discovery, and court proceedings. Family law attorneys can comply by maintaining effective case management systems, meeting deadlines, communicating properly and promptly, adequately preparing for proceedings, and keeping clients fully informed. Diligence is especially critical in custody matters because missed deadlines or court appearances can significantly affect a co-parent's rights and a child's welfare. Sometimes damage caused by a paucity of diligence can have irreversible consequences. Viewers are probably wondering why there are coffee beans featured on this slide. Well, let me tell you, it represents the importance of attorneys remaining alert at all times when representing clients. Sometimes legal practitioners work laborious hours and become jaded. Therefore, adding coffee to the roster may be sine qua non to his or her diligence. So now the following slide examines New York case law involving violations of Rule 1.3 and the consequences of attorney neglect. All right, so we're moving along here. This is slide number 4. So I'm covering case law, and this is in the state of New York, involving a violation of the Model Rule of Professional Conduct 1.3 subsection B, diligence. So here's the case. So here are the facts of the case. So in 1996, Leslie Jones Thomas, who's an attorney, was retained to represent a client by the name of Jacqueline in a divorce proceeding. In February 1999, following an inquest, the parties reached a settlement, and Thomas was directed to file the necessary documents to finalize the divorce within 3 weeks. Now, this attorney failed to complete the task. And because of that, the matter remained unresolved for approximately 15 years. You heard right, 15 years. So in June 2014, Jacqueline's estranged husband contacted Thomas and inquired about the status of the divorce. And Thomas stated that she needed to locate and review the file, but she did not seriously begin looking for it until January 2015, after a disciplinary complaint had been filed against her. So she eventually located the file in her home, filed the necessary documents in November 2015, and the divorce was finally completed in January 2016, which was approximately 16 years after she had been instructed to finalize it. So Thomas ultimately acknowledged that it was her responsibility to ensure that the paperwork was filed in a timely manner, which obviously it was not. So the holding of the case states the following. The New York Appellate Division, First Department, agreed that Thomas had neglected the divorce matter in violation of Rule 1.3b. The court found that her failure to complete the divorce in a timely manner constituted professional misconduct. So the court also sustained an additional finding concerning conduct adversely reflecting on her fitness to practice law. Importantly, the court recognized that the neglect was extremely serious because the divorce was not completed for roughly 16 years, but also considered mitigating circumstances. Thomas ultimately completed the divorce, ultimately completed the divorce. There was no evidence that the client suffered irreparable harm as of the result of the delay, and she presented substantial character evidence and ultimately acknowledged responsibility for her misconduct. So why is this relevant to 1.3 diligence? This case gives readers a very clear example of why Rule 1.3 is specifically important in family law practice. A family law attorney's failure to act diligently can leave a divorce unresolved for years, hence prolonging uncertainty for the parties and potentially affecting related matters such as property distribution, spousal maintenance, and other consequences of marital dissolution. All right, so slide number 5. We're talking about New York State Model Rule of Professional Conduct, Rule 1.6, confidentiality of information. This is a huge one. They're all important, but this one is specifically a serious rule that all attorneys must abide for myriad reasons. All right, so Rule 1.6 requires attorneys to, and this is in New York, to protect confidential information relating to their clients and is fundamental to maintaining trust within the attorney-client relationship. This obligation is particularly important in family law because attorneys routinely handle sensitive information involving finances, medical and mental health records, substance use or misuse, domestic violence, and children. Family law attorneys can comply by limiting disclosures, safeguarding electronic communications and files, and exercising extreme discretion when discussing cases in public or with others. And basically, it's on a need-to-know basis, right? So attorneys must also exercise caution on social media because even without directly identifying a client, details about a divorce or custody matter may inadvertently reveal or disclose the client's identity or confidential information. So the next slide will cover family law. The next slide is going to cover a family matter in case law violating Rule 1.6. Okay, we're on slide number 6, and I want to make a correction. In the preceding slide, at the end of my speaker notes, I had mentioned that on this particular slide, I was going to talk about another violation to the 1.6 Model Rule of Professional Conduct, But no, I actually have a change of mind. I want to now focus on compliance, the importance of compliance, and the case I'm going to use or cite in this demonstration would be New York State Bar Association ethics opinion. So basically, this refers to ethics opinion issued by New York State Bar Association's Committee on Professional Ethics addressing a particular question of attorney professional responsibility. So that's what I want to focus on, compliance, as opposed to a violation. Just to kind of variegate my presentation. So here are the facts. Excuse me. Legal assistance organizations represented unaccompanied immigrant children under the age of 16 in immigration removal proceedings. So the government grant organizations required the legal service providers to submit information about their clients' cases to a database operated by the Vera Institute of Justice, including the children's names, case information, procedural history, motions, outcomes, and information obtained from interviews with the children. The question was whether attorneys could provide this information without violating their obligatory duty of confidentiality pursuant to Rule 1.6, and when consent was necessary, whether a minor could provide valid consent. So here's the holding of this particular situation. The committee concluded that Rule 1.6 prohibits or precludes attorneys from knowingly revealing confidential information without informed consent unless an exception applies. So confidential information includes like information protected by attorney-client privilege, information likely to embarrass or harm the client if disclosed, as I mentioned before in another slide, and information the client has requested remain confidential. The committee specifically relied on an earlier opinion involving attorneys representing children in juvenile delinquency and other family court proceedings, explaining that those attorneys could not participate in research interviews that revealed client confidences without client consent, even for a legitimate research purpose. Interesting, right? Well, the outcome of this particular matter, the committee concluded that attorneys could disclose information that was not confidential, such as certain basic procedural information, when disclosure would not embarrass or harm the child. However, information that could be embarrassing, detrimental, or privileged could not be disclosed without informed consent. Where consent was required, where consent was required, the consent had to be voluntary, informed, and based on adequate explanation of the risks and alternatives. So basically, a minor could provide consent if said minor was capable of understanding the risks and making a reasoned decision. So why is this important or relevant to this presentation? Well, the family court connection is real, but opinion 1059 itself is an ethics opinion, not a family court case. So its strongest, its strongest family court point comes from the committee's reliance on New York State 485, which is in 1978, which involved attorneys in the Legal Aid Society's Juvenile Rights Division representing clients in juvenile delinquency and other family court proceedings. So the committee stated that those attorneys could not participate in a VERA, that's VERA, research study if doing so would reveal their client's confidences without consent. All right, so we're on slide number 7. We're moving along here. So attorneys, like any profession dealing with a code of conduct, they are not absolved from reporting misconduct from a colleague if they are aware of it. So this is what 8.3 covers under the Model Rules of Professional Conduct. This deals with reporting professional misconduct. So if an attorney is aware of his or her colleague exhibiting or engaged in inappropriate, unprofessional, or misconduct, they are obligated to report said behaviors to either the ABA and or the Attorney Grievance Committee in their respective state, right? So I'll give you an example of some misconduct that will fall under that umbrella. For example, lying to the family court, falsifying evidence, misappropriating client funds, serious confidentiality violations, bribery, accepting bribes, or improper influence, dishonesty involving the court, serious conflicts of interest. For example, an attorney represents opposing parties in the same matter, despite a prohibited conflict and without the required consent. So think about it. It's like an attorney representing a husband and a wife in a marital dissolution. Why would you do that? That's competing interests. You're not supposed to do that. I'm just giving an example. Fraud involving a client or opposing party. For example, an attorney knowingly or willfully participating in fraudulent conduct, such as concealing marital assets or submitting deliberately false financial information or instruments to the court. So Rule 8.3 is important in family law practice because attorneys have a responsibility to protect the integrity of the legal system and ensure that serious misconduct by other attorneys does not go unchecked. Family law cases often involve highly sensitive matters such as child custody, domestic violence, finances, child support, and parental rights, etc. And reporting serious misconduct can help prevent attorneys from misleading the court, harming clients, or undermining the fairness of family court proceedings. Also, it deters other attorneys that are thinking about engaging in such behaviors. So ultimately, Rule 8.3 promotes accountability, public confidence, and the integrity of the legal profession. All right, so we're on slide number 8, and I just want to quickly just recap what has already been covered. So I covered 3 different types of model rules of professional conduct in the state of New York, and 2 case law samples to kind of give viewers an idea of what the legal consequences can be if an attorney misbehaves in a legal matter, especially when it comes to family court or family law. And then, of course, I provided an example of an ethics opinion regarding confidentiality with minors. So now I want to kind of shift the focus on filing a grievance against an attorney that you may feel or believe that has violated one or several model rules of professional conduct. Now, when you look at the process, it is quite daunting and intimidating for those that are maybe new at this. So what I decided to do to kind of alleviate and attenuate any kind of anxiety that a person may feel by reading all of this, because again, it's quite voluminous, I'm going to give you a compendious version of the process, just so you're not overwhelmed, okay? So, under Judiciary Law, Section 90 and 22 of New York CRR, Parts 1240 and 806, New York Attorney Grievance Committees are authorized to investigate and determine complaints of professional misconduct against attorneys within their respective jurisdiction. Complaints may be dismissed, result in a confidential letter of advisement or admonition, or when public discipline is warranted, lead to a formal disciplinary proceeding before the appropriate appellate division. The third department's attorney grievance committee consists of 21 volunteer members, which 18 are attorneys and 3 are non-attorneys, and has jurisdiction over attorneys practicing within the third judicial department or attorneys admitted there who practice outside New York. So who practice outside New York. The committee's primary purpose are to protect the public, preserve the integrity of the legal profession, and deter attorney misconduct with alleged violations of the New York Rules of Professional Conduct, generally reported to the Attorney Grievance Committee responsible for the attorney's jurisdiction. Now, if you look at the slide, I have a green arrow pointing to the right. So I'm going to go through the list of the step-by-step process. And like I said, it's quite overwhelming, but it's important because, you know, as legal practitioners, we don't want to condone misconduct and pretend we don't see it, because then we're not setting a good example, right? So we always want to lead by example. If we see something that doesn't look right, and again, that contravenes the model rules of professional conduct, it is best to report it, especially if you're an attorney. All right, so this is slide number 9, and as I mentioned before, it's very important for legal practitioners or even litigants, you know, clients who believe that their attorney or they know of an attorney that violated any of the model rules of professional conduct, to report it, because if you don't report it, there's no deterrence, and guess what? It may keep on happening, right? So I strongly believe that when people see, I'm talking about grievers, when they see how overwhelming the process is, I do believe some people will be discouraged in, you know, following through, because it's a lot of work. Not to say that they're necessarily lazy, it's just sometimes when something's new to a person, it can be very intimidating. I totally understand that. Even though I'm a reader, I love reading, but I'm even like overwhelmed with the process. But just to kind of sum it up here, this is a slide number 9. It's a continuation of slide number 8. And just to kind of alleviate any anxiety that some people may feel when they see how voluminous the process is, I included this beautiful, serene video of the sky with the beautiful sun and clouds, just to kind of counter any kind of anxiety that you may be experiencing when you see the process of filing a grievance against an attorney. So I'm just going to kind of sum it up for this specific slide. So to file an attorney grievance in New York's 4th Judicial Department, you have to identify the griever I'm talking about, identify the appropriate grievance committee, complete the attorney grievance complaint form, or submit a signed written complaint, and provide detailed information about the attorney and alleged misconduct. You then want to attach copies of supporting evidence, which include court orders, pleadings, correspondence, emails, texts, text messages, retainer agreements, billing records, transcripts, and evidence of unauthorized disclosure or other misconduct while retaining the original documents. Now, that's just an abridged version of all the steps that you see here on slide number 9. But again, I don't want to overwhelm anyone. All right, so this is slide 10. And again, I want to continue the theme of including some beautiful, serene, spiritual-oriented stock footage videos of like water and anything to kind of keep people calm that are like reading this PowerPoint, because again, it's very overwhelming. The process of filing a grievance against an attorney that you believe may have violated one of the model rules of professional conduct. All right, I'm going to give you, again, a compendious version of slide 10, which is a continuation from slide 8 and 9. All right, so the complainant should identify any potentially applicable New York rules of professional conduct, sign the complaint, and submit it with supporting documentation to the appropriate 4th Department Grievance Committee at no cost. The grievance staff conducts an initial review to determine whether the allegations constitute misconduct or fall within the committee's jurisdiction, require another process, or warrant further investigation, after which the attorney may be asked to respond. The committee then investigates as necessary by reviewing evidence, requesting additional documentation, and communicating with the complainant or griever and attorney while the grievance process generally remains confidential. Supreme Court Appellate Division, 3rd Judicial Department, scrap that. So after that was the actual reference. I'm sorry about that. That was the parenthetical reference. So after the investigation, the committee may dismiss the complaint, issue an admonition, or refer the matter for formal disciplinary proceedings when the alleged misconduct is sufficiently serious. All right, so I'm going to tell you something. This may be a little brief digression, but it's legal related. But I never forget years ago when I was going through a custody battle with my ex-wife. We had a court-appointed mediator, and I just thought, she had a small little firm, like maybe 4 staff members, and I was saying to myself, how does she stay in business? Because I didn't see like a lot of traffic go through that office. And one day I was sitting waiting to meet with this court-appointed mediator, and the paralegal was on my right, and she comes in with a tub of all these like envelopes. And I remember asking her, I'm like, what is all that? She's like, oh, these are all the cases that we have. Like, what? I was so shocked. Like, if I were to guesstimate, there was over 200 envelopes that she had to send out to various clients. And that's when I realized at that moment how much legal paperwork is involved in like legal proceedings. Like it was so overwhelming. I was like shocked when I saw it. It was overwhelming and very intimidating just to see that. So I'm saying to myself, she only has like 4 staff. So how is she like keeping the lights on? You know, like how is she supporting herself and her staff, and plus all the operational costs, right, to operate or run that firm? But when I saw all the clients that she had, I was like, wow, I was in disbelief. So I'm telling you, in the legal profession, this is one thing I'm learning as I go. You got to really have a passion for it, which I do. But man, whew, the paperwork is very, very overwhelming. It kind of reminds me of when I used to be a licensed guidance counselor in North Carolina, and I had over 400 students that I had to macro manage. Oh, the paperwork was extremely overwhelming. But anyway, I hope that you enjoyed this slide, and we'll move on to the next. All right, so this is slide 11, continuation of slide 10, the step-by-step process that a griever or complainant must go through in order to file a um, complaint against an attorney that he or she, whatever pronouns you want to use, believes that an attorney violated one of the model rules of professional conduct, or maybe several. Who knows? But it's a pretty lengthy process, as all of you may have witnessed in this PowerPoint. And I really, really worked hard to give you the abridged version so you're not overwhelmed and or discouraged from filing a complaint if you believe an attorney has engaged in misconduct. So, the 4th Department's Grievance Committee may dismiss a complaint, issue an admonition, or refer serious misconduct to the Appellate Division for formal disciplinary proceedings when probable cause exists. The Appellate Division has exclusive authority to impose major discipline, including censure, suspension, or disbarment, while lesser matters may result in dismissal or admonition. All right, so slide 12 is going to contain contact information in case if the griever or complainant has questions, if they need a little assistance to kind of walk them through. There is contact information which I'm going to provide on the next slide. So for those that are feeling anxious in case they need to take this route, there is recourse. So I'm going to have that on the next slide. And then slide 13, I'm going to conclude this presentation, and then the following page will have all the references. All right, so this is slide number 12, and this is the contact information for those individuals that need to report an attorney for misconduct. All the information is denoted on this page. Phone number, email, fax, etc. All right, So we're on slide number 14, and I'm going to talk about intersectionality bias in family law practice. So this includes judges and their rulings when it comes to custody matters, attorneys when it comes to representation, and even how they cross-examine and how they perceive litigants based on, again, implicit bias, right? Their race, ethnicity, socioeconomic status, where they reside, their sexual orientation, their religion, their belief systems, etc. Sometimes the biases are implicit, and other times they're overt. But we're talking about, in this particular presentation, about implicit bias, because that is the bias that I believe is the most dangerous, because a person can smile on your face and at the same time judging you. So that's why I feel that implicit bias to me is more dangerous than explicit bias, because at least if a person is expressing or externalizing their biases, and you can see it, perceive it, experience it, not to say it's a good thing, but at least you know what a person's thinking. But when it's implicit, it makes it dangerous, because you think that this person is following the law and that they're an advocate for you, when in fact they could be the polar opposite. So let's talk about intersectionality bias in family law practice. So although family law has moved away from historical doctrines such as coverture and tender years, gender and other forms of bias can still influence decisions regarding which co-parent receives primary custody, even though the laws are written in gender neutral language. The future of family law will require attorneys, judges, guardian ad litems, social workers, and other professionals to combine legal expertise with cultural competence, ethical judgment, technological awareness, and a commitment to impartiality, while concurrently recognizing how implicit and unconscious biases may adversely affect assessments of co-parenting, credibility, finances, domestic violence, and child rearing. Intersectionality further demonstrates that race, gender, socioeconomic status, sexuality, and other social factors are interconnected and can simultaneously create privilege in some areas while exposing individuals to discrimination or oppression in other areas, thereby influencing experiences and judgments within the legal system. And this is what I was talking about earlier on this slide. Reducing bias in family law requires continuing cultural sensitivity and implicit bias education that helps professionals identify their own assumptions, engage in self-reflection, and develop objective approaches for evaluating evidence and family circumstances. Finally, family law professionals should rely on evidence, applicable law, consistent decision-making criteria, and the best interests of the child, as opposed to stereotypes concerning gender, race, income, marital roles, or family structure, while clearly documenting the basis for their recommendations and decisions. All right, so I want to talk about, this is slide 15, about technologies that are used in the legal field, especially family law, to assist attorneys when it comes to data collection. But sometimes technologies can foster biases, and that's something that we definitely don't want in the legal field. So the future of family law will increasingly rely on technology, including electronic discovery, digital court systems, artificial intelligence, and virtual hearings. But these tools must be used responsibly because they can reproduce, as I mentioned before, existing biases. Legal professionals should verify technological information, protect confidential client data, and ensure that technology supplements as opposed to replacing professional judgment while monitoring for unfair outcomes affecting marginalized groups. Eliminating bias also requires accountability through compliance with ethical rules, challenging discriminatory practices, continuing education, diverse representation, and transparent legal procedures. Ultimately, family law should prioritize fairness, evidence, professionalism, and the best interests of the children and families by addressing gender stereotypes and implicit bias so that decisions are based on individual facts of each case rather than preconceived faulty assumptions. All right, so this is the conclusion of my presentation. All right, so, you know, legal practitioners, particularly family law attorneys, must prioritize their professional and ethical obligations because they handle sensitive matters and represent clients during challenging circumstances. New York's grievance process holds attorneys accountable for professional misconduct while protecting the public and maintaining the integrity of the legal profession. Moving forward, family law professionals or practitioners should practice ethically and recognize any biases that he or she, or whatever pronoun you may want to use, may hold, and treat all parties fairly and remain committed to justice, client protection, and public trust. Remember, as legal practitioners, people are placing their trust in our hands. The worst thing we can ever do is betray that individual for our own self-serving agendas. I hope you enjoyed this presentation. There's a lot of information, and I would strongly encourage anyone that's watching this or reviewing this PowerPoint presentation to go over the different steps just to kind of familiarize yourself with the process of filing a complaint. Not that I'm encouraging you to do so, but it's just good to know what needs to be done in order to stop misconduct. Because remember, when legal practitioners are engaging in any kind of misconduct or subterfuge behaviors, it affects all of us.